Good morning, everyone. We're sick of being perpetual fledgling paralegals. So we are really hot stuff with our new legal theory. And today's discussion could actually become the basis of a universal bar exam question.
Today's discussion will further help define concrete delineations of law and justice, taking as its basis a theoretical illustration in which Betty and I are experts on automobile systems and price setting, who have, in the past, helped friends and family members, either individuals or in groups, with the process of verbally negotiating the terms of contracts involving car dealerships in buying personal automobiles.
If we subsequently decide to use our expertise to hire ourselves out as, quote, corporate negotiators, unquote, in terms of helping companies out in the same ways in connection with buying company cars as we have in the past with helping individuals and groups buy personal cars, does the added presence of corporate representation thereby amount to inherent legal representation in addition? That is the point at which a verbal or written contract in a personal setting becomes a verbal or written contract in a corporate setting, the position at which negotiation per se may or may not become inherently a matter of legal negotiation and representation.
In even broader terms, is the science of the bench and the bar, further defined in part by such corporate presence separately from personal presence in a matter, or subsegment of a matter. Is the delineation corporate versus individual, therefore, an elusive J-spot, that is, an overlooked direct corresponding scientific point common to both attorneys and to judges? Are judges to be enforcers of purported attorney-exclusive corporate generic representational privilege? Further stated, could it be that America may not be based on the rights of the individual, but rather on the rights of the corporation? Indeed, debates such as this, even in a non-resolved and non-finalized state, represent a long-awaited benchmark guide for oversight and evaluation of attorneys in the judiciary.
One thing is certain here. Any individual, including an attorney or attorney-turned-judge, is not a jack in terms of being automatically an automobile expert without corresponding direct experience. Therefore, we postulate that, if representational services are involved in contracts, contract negotiation and contract drafting must be treated separately. For to not treat such things separately could amount to allegations of legal malpractice on the part of an attorney due to lack of actual knowledge and experience with automobile systems and pricing, and/or unauthorized practice of law on the part of a non-attorney due to lack of actual knowledge and experience with written contracts. What's more, it might lead to allegations of corruption on the part of a judicial official in the form of ego-masturbatory self-deployment of false personal witness to a matter.
We are paralegals and cannot say we practice law. However, we can say we practice the law. Thanks to us, legal enterprises and court systems can finally operate with more clearly delineated criteria such as the above, with a specific emphasis on removing false know-it-all jack stigmas applied by society at large to attorneys and judges.
Now, let's go to that locked office supply room we know so well.